All right, so our next mini lecture here will cover the topic of sexual harassment under Title VII of the Civil Rights Act. And as we learned earlier in terms of those protected classes, sexual harassment is considered discrimination under the classification of sex discrimination. So as you can see here, courts didn't actually recognize it as such until the late 70s. But now, Title VII does make it possible for individuals to sue their employers for sexual harassment. And as we talk about sexual harassment over the course of the next few slides, I want to keep in mind that the definition itself really refers to any unwelcome sexual advance, verbal or physical in nature. And we'll define the two types of sexual harassment here over the course of the next few slides. I think it's important to mention as we look at this topic that for today's practitioners, this is an increasingly important thing to be aware of, because if you pay attention to what's happening here in the U.S. over the course of the last year or two, there are an increasing number of sexual harassment claims in all industries in this country. And if you follow along with this hashtag #MeToo movement, you know that we really have had a cultural shift in how we view these sorts of experiences. And women have really been empowered to come out and speak out against the harassment they've faced in the workplace. And obviously the things that we hear reported on in the news are often, high-powered celebrities or folks in the media, but this is an issue that is relevant to our field as well in K&R. And keep in mind, this is a field that has an increasing number of girls and women participating, whether it's recreation or sport. And so really important for us as practitioners to be aware of, not just because it's wrong and it's discriminatory to sexually harass employees, but also could be very costly to your organization in terms of the lawsuit and the fallout that comes from that. Real quickly here, a couple of examples that I'll post to RegGiNet. But you can see, again, this isn't something that's a siloed issue for other industries or sectors. Sport and recreation organizations face these sorts of issues every day. The National Park Service has recently done some studies to show that there's really widespread sexual harassment occurring across the country at their different entities. And now, in a lot of ways, that sector is having to react and change a lot of what they've been doing. In sport, unfortunately, we've seen several cases of sexual misconduct, not just from players, but also front office staff. The Dallas Mavericks was revealed 2 years ago that there was widespread sexual misconduct happening from some of their upper executives. And so, that resulted in a fairly large payment from the Dallas Mavericks team owner to the league in terms of fines. So you can see that these have pretty big implications, not just on the individuals that are affected by them, but the organization at large. So certainly important for us to cover these legal issues in terms of sexual harassment. Okay, so we have two different types of sexual harassment that are covered under Title VII. We have quid pro quo, and before we look at the definition here, I'll just tell you that this is a Latin phrase, and it means this for that. So you can see how that might be helpful in explaining what quid pro quo is. Basically, it occurs when a subordinate's employment conditions are based upon entering into a sexual relationship with a superior. So there's a proposed exchange of sexual favors for something in return. Generally, that is employment related. So for example, a manager at a fitness center offers a promotion to an employee in exchange for sexual favors. That would be an example of quid pro quo. The other type of sexual harassment here is hostile working environment. So this type of harassment occurs basically when the workplace itself, the culture of that workplace, is permeated with conduct that has the effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment. As you can imagine, this type of sexual harassment, occurs when employees are telling dirty jokes, making inappropriate comments, inappropriate behavior that is impacting others in the workplace. So while quid pro quo is generally kind of a one-on-one situation, hostile working environment harassment could be more widespread, and then it might be impacting more than one employee. Either way, both are very serious and troublesome. Those quid pro quo cases tend to be more severe in terms of the law because they do include an actual exchange of sexual favors, and the hostile working environment does not actually require that, as you'll see here as we look at the elements. Okay, so each of these cases is taken on their own in terms of an actual legal claim. So if a plaintiff is filing a quid pro quo sexual harassment case, they would have to prove these three elements. So one, they would have to show discrimination based on a protected class. And again, this goes back to what we looked at with the original Title VII employment elements, which again, they would just have to be able to show that, yes, sexual harassment indeed is covered under Title VII of the Civil Rights Act. From there, they would have to show that there was an actual request for sexual favors. Again, that could look a little bit different depending on the situation, but there has to be some kind of request from the superior for sexual favors. And then finally, the submission to that advance would need to be a condition for receiving some kind of job benefit, or failure to do so or refusal to do so would result in some kind of detriment to the job. So again, in order for there to be quid pro quo, there has to be this exchange or this attempt for exchange, right? Request for sexual favors by the superior, and then either accepting that leads to some kind of positive job benefit, or refusing that leads to some kind of detriment, like losing your job or potentially getting demotion. So if those three elements are there, you could be successful in a quid pro quo case. Keep in mind, we said this sort of sexual harassment is deemed very severe in the eyes of the law. And because of that, if a plaintiff employee is able to prove those elements, then the employer or the corporate entity would be deemed strictly liable. So this is kind of similar to what we looked at in our negligence unit with vicarious liability. Basically, that liability of the employee who has committed the quid pro quo, their liability could be passed up to the corporate entity, again, regardless of whether or not that corporate entity was even aware of the situation or knew about it, because these are deemed to be such an extreme case of sexual harassment. So as you can imagine, this could potentially result in a pretty severe lawsuit against the organization, monetary damages, all of these things. I'll give you an example of a real-life quid pro quo case in our field. This was a case against 24-Hour Fitness. Basically, one of the employees filed a quid pro quo sexual harassment case against his female boss of a 24-Hour Fitness. She had several sexual advances made toward him, and even offered him to travel to Las Vegas with her in exchange for some kind of sexual favor. Once he denied that or ignored it, she then diminished his chances of getting a promotion by falsely criticizing his work performance. So that's an example of a quid pro quo sexual harassment case. Again, there doesn't actually have to be a sexual act in order for you to be successful in this particular case. There just has to be that request for sexual favors, and then some kind of either submission for that as a condition for a job benefit, or refusal for that for a job determinant. And we know in the case of 24-Hour Fitness employee, there was detriment to his job by denying or refusing those advances. So that's quid pro quo and the elements that have to be proven. As we move on here, there are different elements for a hostile work environment case, again, because the type of sexual harassment is a little bit different. Again, here, we still have to be able to show discrimination based on a protected class. And again, this just goes back to our Title VII protected classes. Again, we know sexual harassment is included in that. Second element here is the plaintiff would have to be able to show that they're the subject of unwelcome advances. So basically, this just means that you are directly being harassed or addressed by the advances that are occurring in the workplace. So again, that could mean that you're sitting near someone who's constantly making comments or jokes about your appearance, and that's an unwelcome advance, not something that you are seeking or want to occur. So that's subject of unwelcome advances. The third element here is that the harassment itself has to actually affect some element of your employment. So you can see here the element itself says a term, condition, or privilege of employment. Basically, you just have to show that this environment that's created from the sexual harassment is affecting your ability to do your job. So perhaps the employee that is harassing you on a daily basis is making it difficult for you to go to meetings because you don't want to be around this person, or it's a distraction to you when you're trying to make phone calls. Any of these things could be an argument for harassment affecting a term of employment. Here's another example case in our field. This is a specific hostile work environment case. So a lifeguard at a public beach brought a hostile work environment case against her supervisor and the city itself, which owned the beach. So the city had recently updated its sexual harassment policy, but it had not communicated it to lifeguards and supervisors. And in this particular case, which actually went all the way up to the Supreme Court, the city and the supervisor were both found liable because they had created the system to provide training, but they hadn't actually delivered it. So this gets into our next point here, which is that in a hostile work environment case, that concept of strict liability doesn't necessarily occur if the organization can show that they put in reasonable care, prevention, and action to keeping these sorts of things from happening. So if a K&R organization has sexual harassment training procedures that they have all their employees go through, if it's clear that they are trying to prevent these sorts of things from occurring, then they may not be strictly liable in a hostile work environment case. Again, that's a little bit different than the quid pro quo cases where they were regardless, right? Regardless of any actions they were taking in a quid pro quo case, that liability could go all the way up to the corporate entity. But in a hostile work environment case, because it's not deemed to be as severe, if the organization can show that they've taken some steps, some reasonable care to try to prevent this sort of environment, then that liability may not go up to them. So again, this goes back to the importance of having policies in place, making sure that you're properly training employees so that this sort of thing doesn't happen at your organization, making sure there's actual accountability for those that do participate in either hostile work environment, sexual harassment, or quid pro quo. Supervision is important, particularly if you're dealing with a lot of young employees who may be unexperienced in the workforce. And then ultimately, a lot of these issues surrounding sexual harassment can be prevented through having a workplace culture that simply doesn't accept this kind of behavior. And that kind of culture can be positive if it's done correctly. But if a culture exists where that sort of behavior is ignored or pushed under the rug, much like it was with the Dallas Mavericks, and then that can be really harmful to your organization. So there are things we can do as practitioners to try to eliminate or at least minimize risk for these sorts of claims. Okay, I'm going to pause right here and then come back to you with a very short lesson here on the Age Discrimination in Employment Act.